Hi, welcome to the second week of bonus materials for Professor Akil Amar's constitutional law course. My name's Daniel, and I'm one of the teaching assistants for Professor Amar's course. I'm a second-year student here at Yale Law School. Last week, we had a discussion forum event in which a lot of people posted questions, and me and some of the other TAs had the chance to respond to those questions on the discussion forum. It was a really fantastic time, and we were really impressed by the volume and quality of the questions that you guys were asking. This week, we wanted to take the chance to address a couple of questions that we didn't get a chance to respond to last week, and do it in a more personal way with me discussing them here on air. So first off, I say that we're not going to be able to get to even close to the full volume of quality questions that people have been asking on the discussion forum, but we just wanted to bring up a few that kind of highlight the sort of high-quality discussion that's been going on. So the first question comes from a post originally by Michael Blanco. And Michael asked, we're studying the Constitution here, but is the Constitution itself even legal? Which is an interesting question to ask, because when the Constitution was created, the United States wasn't the United States. There were 13 states, and they were bound together in the Articles of Confederation. When the Constitutional Convention actually convened in 1787, they were originally instructed to come up with revisions to the Articles of Confederation. And as Michael points out, the Articles of Confederation claims that in order to change anything, you need unanimous consent of all the states. In fact, here's what the Articles of Confederation had to say about its own amendment. And this is from Professor Amar's book on page 30. It said, quote, "The Articles of Confederation shall be inviolably observed by every state, and the Union shall be perpetual. Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state." So that seems pretty unambiguous. It seems that the Articles of Confederation said, if you want to change anything, you need the consent of every state. But that's not what the framers at the Philadelphia Convention did. If you recall, in Article 7 of the Constitution that the framers created, they said that as long as 9 states were willing to ratify the new Constitution, it would go into effect. So how was it legal for the framers to produce a Constitution like that only required 9 of 13 states to consent to it, when the Articles of Confederation, which was a binding legal document itself, said you need every state's consent? So here's one potential answer to that problem that Professor Amar talks about in his book, and that's that the Articles of Confederation wasn't like the Constitution. It was really a treaty. It was a league. It was an agreement between a bunch of different sovereign states. And according to principles of international law prevalent at the time, a state wasn't obligated to follow a breached treaty. So, if they'd entered into a compact with another nation and then that nation didn't honor its obligations under the compact, the first nation had no obligation to continue to honor its own. So the way that the framers understood the Constitutional Convention, and possibly the best way for us to understand it retrospectively, is that they were addressing a breached treaty, that the Articles of Confederation was a breached treaty, that states had failed to honor their obligations under the Articles of Confederation, and therefore the founders were were entirely justified in saying, we're going to create a new agreement, we're going to create a new nation. And they were a little ambiguous at the time about exactly who breached and how, and this was understandably a delicate question. Nobody wanted to be throwing around accusations. Also, depending on which states agreed to ratify the new Constitution, it might feel different which states you had to say had breached the old Articles of Confederation in order to make things legitimate. But in terms of the way to think about how was it legal for the framers to create the Constitution in a way that didn't seem to follow the procedures of the Articles of Confederation, thinking of it as a breached treaty is a good place to start. So another great question that wanted to address was something originally posted by Fernando von Hinke, and he asked about the right of states to secede. and whether the Constitution actually explicitly tells us whether states do have the right to leave the Union or not. And this sparked a really fascinating and extensive discussion with, I think maybe even hundreds of posts. And it's an important question, and one that we're going to come back to a little later in the course when we talk about some of the constitutional upheavals around the Civil War. But it's important to think a little about it now. And here's the answer that Professor Amar highlights. And that's that unlike the Articles of Confederation, which we were just talking about, the Constitution really wasn't an agreement between sovereign states. And there's several features of the Constitution that point us toward that conclusion. So one is the preamble itself. And the preamble doesn't say this is a compact. It doesn't say this is a league. It doesn't say this is an agreement. It says this is a constitution. It is constituting a new nation out of constituent parts rather than a loose confederation of sovereign states. Another piece of evidence is Article 6, the Supremacy Clause, which says that the Constitution is the supreme law of the land, and nothing that any state can do will supersede the Constitution, which seems to imply that the states really aren't sovereign anymore. If North Carolina decides it doesn't like part of the Constitution, it wants to do something different, it doesn't matter. It can't repudiate the Constitution. Another interesting feature of the Constitution that suggests a kind of that does not suggest that the sovereign-state relationship is not what we're talking about is the difference between Article 7, which describes ratification, and Article 5, which describes constitutional amendment. So the Articles of Confederation, as we discussed earlier, requires unanimity to change the agreement, right? And that suggests that every state who's a party to the Articles of Confederation is retaining its sovereignty. It's not going to be forced to do anything new under the Articles of Confederation unless it agrees. But that's not how the Constitution works. The Constitution says, once you've signed up, once you're part of this new nation, we have an amendment process laid out in Article 5. It doesn't require unanimity. If 3/4 of the other states, and then 2/3 of both houses of Congress, agree to a change, you are going to be bound by that change. And what that implies is that the individual states are not sovereign anymore. They're part of a group, and they have to follow the dictates of that group, even if they don't like it. A final interesting thing that Professor Amar points out is that the anti-federalists, the people who oppose the adoption of the Constitution, threw around this accusation a lot at the time of ratification. They said, you know, we're effectively dissolving the states here. We're not going to have sovereign states anymore. But the Federalists, people who are promoting the Constitution, they didn't try to deny that charge. They didn't claim, no, you guys have got it wrong. They said, yeah, that's right, and that's what we should be doing. Federalist 11, which is one of the Federalist papers that were written to support the adoption of the Constitution, specifically talks about the need for a strong and indissoluble union. And so that's what both the supporters and the opponents, actually, of the Constitution seem to have thought they were doing, and that's what they did. So then there's one final point I want to bring up, and that's a question that was originally brought up by J.R. Sedevy, and that's about the Constitution's size and scope. And J.R. asks, you know, the Constitution is really brief. It's only a few thousand words. So how is it that we have such a short Constitution? And then you look at modern legislation like the Affordable Care Act, or Obamacare as it's often known. It's hundreds and hundreds of pages long. How is it that we need to write these extremely extensive statutes when we created a Constitution that was so brief and succinct? So this brings up a really interesting point about American constitutional design, in that a remarkable feature of the American Constitution is its brevity. So, by contrast, the Indian Constitution is 117,000 words long. That's 25 times longer than the U.S. Constitution. So, America's founding fathers seem to have made a very deliberate choice to go with a shorter document. So why did they do that, and what can we understand about the project as a result? Jason Jones actually had a great response on this thread, and he compared the difference between writing a constitution like the framers did in 1787 and passing a statute today as the difference between creating a blueprint for a house and adding a sunroom. And he pointed out, the levels of detail you might want to specify, the amount of implementation and specifics that need to go on in those two processes are very different. And I think that that's really the right way to think about it. To kind of drive this point home, I'll say one of the most famous lines in the history of the U.S. Supreme Court. So this is from a case called Marbury versus Madison, which is going to come up in this course. It's from 1803. It's arguably the most important case in the history of the Supreme Court, and this is arguably the most famous line from this opinion. And this is what it is. We must never forget that it is a constitution we are expounding. Doesn't sound very exciting, right? I mean, you might think, like, if that's the big payoff, why am I taking this constitutional law class? But it hits at this idea that we've been discussing with this question, and that's that the Constitution isn't a detailed code. It's not like the tax code, say, which specifies exactly what's going to happen in a lot of different circumstances. It's a blueprint. It's a framework. It creates the conditions for future politics that are going to fill out the details. And quite possibly, that flexibility that the framers built into the system is why our Constitution has been able to endure for so long. So thanks for posting so many great questions. I'm sorry we only had the chance to discuss a few of them here today, but we really look forward to more events like this, more interactions on the discussion forum, and more opportunities to hear what you guys are thinking about the course. So thanks so much. Hope you're enjoying it. First off, I say that we're not going to be able to get to even close to the full volume of quality questions that people have been asking on the discussion forum, but we just wanted to bring up a few that kind of highlight the sort of high-quality discussion that's been going on. So the first question comes from a post originally by Michael Blanco. And Michael asked, we're studying the Constitution here, but is the Constitution itself even legal? Which is an interesting question to ask, because when the Constitution was created, the United States wasn't the United States. There were 13 states, and they were bound together in the Articles of Confederation. When the Constitutional Convention actually convened in 1787, they were originally instructed to come up with revisions to the Articles of Confederation. And as Michael points out, the Articles of Confederation claims that in order to change anything, you need unanimous consent of all the states. In fact, here's what the Articles of Confederation had to say about its own amendment. And this is from Professor Amar's book on page 30. It said, quote, the Articles of Confederation shall be inviolably observed by every state, and the Union shall be perpetual, nor shall any alteration. Hi, welcome to the second week of bonus materials for Professor Akil Amar's Constitutional Law course. My name's Daniel, and I'm one of the teaching assistants for Professor Amar's course. I'm a second-year student here at Yale Law School. Last week, we had a discussion forum event in which a lot of people posted questions, and me and some of the other TAs had the chance to respond to those questions on the discussion forum. It was a really fantastic time, and we were really impressed by the volume and quality of the questions that you guys were asking. This week, we wanted to take the chance to address a couple of questions that we didn't get a chance to respond to last week, and do it in a more personal way with me discussing them here on air. So